Is everybody back? Hmm? Okay. So, we have now gone up to requirement B, and then I lost you guys. So, okay. So do we all understand that with interim applications, where you're asking for an interim interdict, you don't need to establish a clear right, okay? In the sense that you don't need to prove the right that you are relying on for the relief that you ultimately want. You need only establish a prima facie right, even though it's open to some doubt. Okay. So you remember in final interdicts, the requirement that you had to meet was that there is an apprehension of an injury. So if the applicant comes and applies for an interim interdict and is able to establish a clear right, he doesn't need to show that there will be irreparable harm if the court does not grant the interim interdict. All he would have to show in those circumstances is that he apprehends that he will suffer an injury, as in something that might happen. So that's the difference between the two. Okay, so starting off with when you have with a final interdict, all you have to establish is, once you've established that you have a clear right, then you have to show the court that there is an injury which is actually being committed, which is continuing, or that there is a reasonable apprehension of an injury happening. So, as I was explaining, that there is a possibility of Nelly, whilst we have an agreement for the sale of ours, she has signed an agreement with Charlotte, and I suspect that she's going to transfer the house to Charlotte, which means I won't be able to get the house. Okay? So I'm apprehending that injury to my right in terms of the contract that the two of us have. Okay? Now, if you have an interim interdict situation where the person, essentially what the person is asking the court is, please stop Nelly from transferring the house to Charlotte, pending the finalization of an action which I intend to institute for an order that Nelly be compelled to transfer the house to me. So at that point in time, I'm not asking the court to order Nelly to transfer the house to me. And an interim interdict you would normally seek on an urgent basis. A final interdict can be on an urgent basis, but in most cases it would be on in the ordinary course. Lorraine? So when they're asking for an interim interdict, it's just to stop everything that's happening right now, because if Nelly transfers the house, then I will suffer irreparable harm, because that house I actually intend to buy. I bought it with the intention of putting up a creche. And if she sells a house to Charlotte, I will not be able to find a house in that same location, which is perfect because most of my customers are close by. Then I will have to go look for something somewhere else, and it would mean that I might lose customers, and what you are telling the court is it will be difficult for me to even assess the damages, but that house would be gone by then. By the time I come to court and I get an order for the house to be transferred to me. That's why it says here that you might suffer irreparable harm if the interim relief is not granted and I ultimately succeed in establishing my right. The next one is that the balance of convenience favors the granting of the interim relief. Now we are back to that weighing up of the parties' rights the applicant versus the respondent. So the harm that the applicant will suffer is if the interim relief is not granted, is weighed up against the prejudice the respondent will suffer if the interim relief is granted. And then you look at, when you consider the respondent's position, you look at in the event that the case actually goes against the applicant. So you say, if I don't grant the applicant this relief now, and she succeeds in her case eventually, I must look at the harm that she will suffer if I don't give the interim relief. Then if you look at the respondent's position is, if I do grant the interim relief now, and the respondent eventually succeeds in defeating this case by the applicant, what harm will that respondent suffer as a result? So you take those two things and you weigh them up, a balancing exercise, and then whichever, where the scales weigh the most, that one will then guide you in your decision. So the stronger the probabilities are in terms of the applicant establishing that right, so the closer the person is to establishing the right, the more the probabilities will also be in their favor. But the further away the person is from establishing the right, in the sense that there's a lot more doubt on the right, the probabilities will be against that person. The parties will obviously tell you what kind of harm they will suffer if you grant it versus if you don't grant it, and you weigh those things up against each other to see which one can you actually sacrifice in the process of your decision-making process. And then the last one again is that the person has no other satisfactory remedy, the same as in the final interdict. It must be a legal remedy, and it must be something that gives you adequate and similar protection as the interim relief would have given you. So those are the requirements of an interim interdict. I'm just going to read you something from another case which might give you also a bit of a better understanding of how the courts look at these things. This case is Olympic Passenger Services, Pty Limited, versus Ramlagan, R-A-M-L-A-G-A-N, R-A-M-L-A-G-A-N, 1957, 2 SA 382 in brackets D, and the quote appears at page 383 C to G. It thus appears that where the applicant's right is clear and the other requisites are present, no difficulty presents itself about granting an interdict. At the other end of the scale, where his prospects of ultimate success are nil, obviously the court will refuse an interdict. Between those two extremes fall the intermediate cases in which, on the papers as a whole, the applicant's prospects of ultimate success may range all the way from strong to weak. The expression prima facie established, though open to some doubt, seems to me a brilliantly apt classification of these cases. In such cases, upon proof of a well-grounded apprehension of irreparable harm, and there being no adequate ordinary remedy, the court may grant an interdict. It has a discretion to be exercised judicially upon a consideration of all the facts. Usually this will resolve itself into a nice consideration of the prospects of success and the balance of convenience. The stronger the prospects of success, the less need for such balance to favor the applicant. The weaker the prospects of success, the greater the need for the balance of convenience to favor him. I need hardly add that by balance of convenience is meant the prejudice to the applicant if the interdict be refused, weighed against the prejudice to the respondent if it be granted. So that sort of puts in a nutshell pretty much what you need to look at and how you need to weigh it up. So where the court grants an interim interdict, the court may also impose certain conditions which may take care of the prejudice or harm, the prejudice of the respondent in the circumstances, by, for instance, saying that the applicant must give security for in the event that they lose. So this will take care of potential financial prejudice that the respondent might suffer. So those are all within the discretion of the court. This is just the court's approach in looking at the evidence when considering whether to grant an interim interdict versus what it will do in a final interdict. So in the final interdict we've discussed, it's pretty much the respondent's case. But here, if the applicant does not establish a clear right, the court would then take the facts as set out by the applicant, together with any facts set out by the respondent, which the applicant cannot dispute, and then consider whether, having regard to the inherent probabilities, the applicant should not on those facts obtain final relief later on. So you're sort of making a forward judgment in the case. So that's pretty much the approach that the court takes when considering whether to grant interim relief. So you take the facts that have been set out by the applicant, together with anything that the respondent has said, which the applicant cannot deny. Yeah. And then you consider, looking at the inherent probabilities, whether the applicant would obtain final relief eventually if the matter goes full-blown. So they usually say that this one is decided on the applicant's version. Okay, review applications. They are dealt with in Rule 76. So the idea, I just want you to understand, the idea of this training is not to deal with substantive law. So much of reviews would be substantive law. So I've taken a few things that I've put together here. Some of it is in the rules and so on, and then yeah, just so that you can get it. A review is not an easy thing. So hopefully, if you do get the opportunity to go act, you won't be thrown first time with a review. They, according to the rule, must be by way of application unless the law, any other law says otherwise. So the SAPA matter that we discussed in relation to discovery in applications, that was a review. One of the points that the other party raised at some point was that because of the disputes between the parties, the applicant should have brought the review the applicant should have foreseen that there would be disputes and should have brought an action instead of a review. What Judge Damasep said is that the rule is clear with reviews. Unless so prescribed by law, they must be by way of application. That's our Rule 76.1. Okay, so reviews always concern decisions by magistrates, presiding officers of courts, chairpersons of administrative bodies, the decisions of administrative bodies or tribunals, administrative officials, and so on. So those persons, whoever it is whose decision you are reviewing, so whoever's decision it is that you are reviewing, obviously the application must be served on that person. And as I indicated way in the beginning, any interested party, somebody who might be impacted by whatever relief you are seeking. Common reviews are tender awards, so the tender board will be sued and the ministry whose tender it is will be a part of the application. You will also have whoever is the successful tenderer and other tenderers who were involved in the tender process as respondents. Just remember, with like a tender board, you don't sue the tender board because it's not considered a legal person in that sense that can be cited as a party. So it will normally be the chairperson of the tender board with the ministry, you also don't, it's not, I know there are law reports that talk about the ministry, but it's actually the minister that must be sued, because the ministry is not a juristic entity. Or you simply sue the government represented by the minister of so-and-so. With a municipality is not a legal person, it refers to an area. So it should be the council of the municipality of Windhoek or whatever that must be sued. If you look at the act, when they say municipality, they actually define municipality as a certain area within certain boundaries. Okay. The application, in the notice of motion, the person must identify the decision or the proceedings that they seek to review. So the decision by the council of the municipality, taken on 20 November 2016, in terms of which it refused to grant me a rezoning of my property or whatever it is that you are applying for. So it must be clearly specified so the court knows exactly what decision it is considering. And you'll be surprised, sometimes people get it all wrong. Basically, with an appeal, you deal with the merits of the decision. You're saying that the decision is wrong because it's not supported by the facts or the law. And that decision is normally, appeal is considered purely on the record that is before the court, no extrinsic factors. With a review, what you are saying is that the person acted irregularly, and it could be apparent from the record, but it could be other factors as well. You can say the person was biased because they didn't take into account certain considerations. She switched off the record or the recording machine, and then she went off on a tangent or whatever, switched it on again, and then when she gave the judgment, she took into account all those things that she said there. It's not on the record, but you know about it. So you can add that in your review, for instance. So with a review, it's not about the correctness of the decision. It's really about the process that was followed by the person in arriving at that decision. So in terms of Article 18, we are all entitled to fair and administrative justice, fair and reasonable administrative justice with presiding officers. They must also act fairly. They must give you proper audi. Both parties must have a proper hearing. And if they are not given that, then it's an issue of regularity. So the decision was arrived at irregularly, and therefore it must be set aside. And normally it will be referred back to the person to follow a proper process and then make a decision. So what you were asking was, now what do you do as the presiding officer? You have a choice, because you are also expected to provide reasons for the decision that you have arrived at. So you have a choice to defend the matter if you want to, or you can just provide your reasons and let the court make its call. So I believe she probably opposed the matter and then took part in it fully in terms of defending her actions and that kind of thing. That's probably why the costs were awarded against her. Then, well, you'll have to look at all the facts and also consider why. The courtroom is not just two people in the courtroom. There's other parties there too. There's the stenographers, there's the court orderly, and so on. So you would wonder why none of those people were asked to depose to any affidavit to confirm that happened. So it's obviously, remember, the applicant has to prove their case. So it's not necessarily that the applicant will fail if there's that he says and she says situation. The court will look at all the other surrounding factors that are raised in the papers to decide which version to accept and so on. So the order that will be asked for is for the respondent to show cause. It's framed almost like a rule nisa, but it's not really. That's not what they are asked. Not be reviewed and set aside or corrected. So reviewing is looking at whether the person was acted reasonably and fairly and applied a fair procedure and those kinds of things. There are authorities which basically say also that the Constitution has actually introduced an element of looking at the substance of the decision as well. I believe there's a case by Judge Olin Lissa, this is the Minister of Health and Social Services, I think, or the other way around. It's a very long judgment. Somewhere there he says that, but it's a very long judgment. But in essence, I think what the Constitution did is to say, if on the facts of it, your decision is not reasonable, which looks at whether or not your decision is right or not, then it should also be set aside in a review application. But that is going into the substance, or the substantive law here. To be corrected means that the court must now make the correct decision. Not just review and set aside, but must actually give you what you ultimately wanted. So the court must now order that you be awarded the tender or whatever it is that you are reviewing. Whether the court will do that in a review is another story. I'll touch on that in a moment. The respondent will also then, in the notice of motion, be asked to provide reasons for the decision and to serve a copy, not the copy, it's the, you serve a copy of the record on the applicant, and the original must go to the registrar. Okay, so as soon as the review application is served, unlike all other applications, the application is then assigned to a managing judge. So in review applications, basically the case is case managed from the time that the application has been launched, just like in action proceedings. In fact, it's a bit earlier than action proceedings. Because in action proceedings, it will only be case managed if defense a notice to defend is filed. Here, the review application is seemingly already assigned to a judge once it has been served, and the case management judge will then manage the process. In normal applications, if you can remember, the managing judge is only assigned after all affidavits have been filed or the pleadings are deemed closed. When I say deemed closed, it means that the time periods for the filing of an answering affidavit had passed and the person has not filed an answering affidavit, or the time period for the filing of a replying affidavit has passed and they have not filed it, then the pleadings are deemed closed. Okay. So when the applicant receives the record, they have 10 days within which to supplement the affidavit and notice of motion. So once you have the record, you go through it, and you might actually pick up that there's more in terms of irregularities that were committed by the decision maker. Then you can supplement your notice of motion, you amend your notice of motion, and you can add, or you can change your review relief that you're seeking or whatever. So you might have just asked for the court to set aside the decision. Now you might amend it and say, I want the decision to be corrected because of this and this reason. And you can also, in the supplementary affidavit, you can refer to the record and make, obviously, a case with reference to what is in the record as to why you say the decision was taken irregularly or the process was irregular or whatever. You were unfairly treated. The respondent or respondents can oppose the application within 5 days of service of the application or of any amendment of the application. So this causes a bit of confusion in practice, really, because you might not oppose after service because you're waiting for this supplementing of the papers, and then the applicant thinks no, nobody's opposing, so they go and try and get an order. But that's why I think applications of this nature are judge managed from day one, literally, to make sure that those kinds of things don't happen. It's usually safer for the respondents to just file the notice to oppose within the 5 days of receiving the application. So before, in the old rules, it was also the same, but your answering affidavit, you had 30 days within which to file it, but 30 days from the time that you file your notice to oppose. So it was, you just sort of had a little bit of an advantage if you waited to see if the applicant supplements his affidavit, because then you have longer time within which to answer to the application. That's not the case anymore. Now the answering affidavit must be filed within 20 days of the time allowed to the applicant to supplement his application. So after the record is received, the applicant has 10 days. If they supplement, then fine. If they don't supplement, you first count 10 days from the time that the record has been filed, then you count your 20 days after that to determine when you must file your answering affidavit. And then the applicant has 14 days to reply. So the 14 days I get, because the rule only says that the applicant has the same time periods or the same rights and obligations in regard to replying affidavits as set out in Rule 65. Rule 65 is the rule that deals with normal applications, and there it says that the replying affidavit must be filed within 14 days of the answering affidavit. Okay, so this is a sort of a clean timeline, which assumes that nothing happens in between. But the rule also makes provision for if the applicant looks at the record and sees, but there are certain documents that are missing which should have been discovered as part of the record, then the rule allows for the applicant to give notice to the respondent, the decision maker, to produce specified documents which they think are still in the possession of the decision maker. And then the respondent must supplement the record by making the documents, first of all, available to the applicant for inspection, and then inspection and copying, and then filing the originals of the extra documents with the registrar. If there is a dispute about documents that needs to be discovered, then the court must, in its discretion, give guidelines and directions as to how that dispute is to be resolved. And it's normally by way of an interlocutory application, so that the applicant files an interlocutory application in which it seeks certain documents, and the respondent answers and deals with whatever it is that they need to say there. And the court then hears the parties and decides whether to order the record or not. So record is not necessarily the limited record that we are used to in terms of an appeal record. The authorities have defined it as every scrap of paper throwing light, however indirectly, on what the proceedings were, procedurally and evidentially. So every little thing. If somebody, so you will see with tenders, normally you will have different committees that will look at the tenders. In the ministry, there will first be the ministerial tender committee who will consider this tender, and then it goes to the tender board, or there's something else as well. So somebody else does the technical, considers the technical tender, and the other one considers the financial tender, and then it goes to the tender board. So all those things as they served in those different processes. Those are all things that form part of the review record. And all of that must be discovered. So it's a much more generous interpretation, including everything that could possibly have influenced the decision maker in arriving at the decision that it. So once we are now satisfied, so this is what I was just referring to the relevant rule here. Okay, once the applicant is satisfied that the record is complete, he must verify the completeness or the correctness of the copy of the record that was served on him by physically going to the registrar's office and comparing what he has with the original record that serves or that is lying at the registrar's office. And if he's satisfied, then he must certify the record, make copies, serve 2 copies on the registrar, and on each of the other respondents a copy, so that the original does not go around all over the place. It stays there with the registrar, and the court also, when it gets a copy, it's normally so when it gets the record, it's a copy of the record, not the original, because you don't want to lose the original. In practice, what often happens is, especially where government attorneys are involved, they just serve a copy on everybody. But it's still the responsibility of the applicant to make sure that the record has been certified as correct, so that everybody has a copy that is certified as correct. Okay, so remember I said that the court can review, set aside, and correct the decision of the decision maker. That correct is not going to happen all the time. Even if the court says a decision was arrived at irregularly and should be set aside, it will not generally substitute its own decision for that of the decision maker. The reasons are basically, there's a separation of powers. The executive has their powers, the judiciary has their powers, and the legislature has their powers. So a lot of these decisions that come to the court for review concern either technical issues or policy decisions, which the court is not experienced or does not have the expertise to make a decision on. And it's not for the court to interfere with policy matters. It's not their job. So if that is the issue, if it's a polycentric issue that the court is dealing with, or it is something that requires technical expertise, then the court will not ordinarily correct the decision by itself taking the decision. It will rather refer the matter back to the decision maker for the decision maker to make that decision. It will obviously be different when it's, for instance, a decision taken by another tribunal, like a judicial or quasi-judicial tribunal, or a magistrate. If it's a decision which falls within the expertise of the court, and the court considers that it would just be a waste of time to just refer it back, or if the court feels that it's clear that this person is not going to change their mind anyway because they are so biased, then it will make that decision. But otherwise not. So the normal order will be to review and set aside, and then it will be referred back to the decision maker to reconsider. So those are the cases that you can look at for how the court considers its discretion or applies its discretion in a review matter. Other instances where the court will also decide to make the call is where there has been such a fundamental failure of procedural fairness, and the decision has nothing to do with technical or specialized consideration, then it might also make a call. It didn't happen in that case, but it was a comment made by the court in that case. So what you would often find, especially with these tenders and things like that, is the person will come on an urgent basis, by way of an urgent application, to stay the award of the tender if it has not been awarded, or if it has been awarded, to stop the parties from entering into an agreement or from implementing the tender, pending the review. So they would normally have a Part A and Part B. So Part A will deal with the urgent application for interim relief. Part B will deal with the review relief. So Part A will be decided in the urgent application, and then the Part B will then proceed. So if you get the interim relief, then the status quo is maintained, and you can go ahead with the review, and the court then, once the review is done, then obviously the process, depending on what the outcome is, obviously goes ahead or is reconsidered or whatever. So with things like those, like tenders and that kind of stuff, where the consequences of the decision could be that there might be finality to the situation, such as, say for instance, there's a tender out for the building of the judiciary's head office, and you don't stop the tender, and so the parties go ahead and they build the building and whatever. Then you will end up with a situation where the court will look at that and say, and yes, it is so that the decision is wrong, because it was, or not wrong, but that it was procedural, the procedure that was followed was irregular, and that the decision should be set aside. But because of the consequences of you not having stopped the process, everything is done now, so now I can't set aside the decision. So that's sometimes what happens. And that is what the unfortunate thing is. What happened in that case is they abandoned the urgent application, the applicant, and the court said that they shouldn't have, because if they had received, if the interim relief had been granted, the whole process would have been halted, and then the whole process would have had to start all over again. But now the court said, yes, there were irregularities, and yes, the decision is wrong and everything, and that's why the court awarded costs against the roads authority. But that is the risk that you run if you do not have that two-pronged approach of asking for interim relief pending the review. So it won't always be the case with every kind of administrative decision, but specifically these kinds, you are advised to actually do it that way. So the other thing is also, once you've had a decision reviewed and set aside, you have a remedy where you can actually get sue for damages. But it's very difficult in a review with administrative decisions to get damages, because you have to show malice. So bona fide errors by administrative officials does not give rise to damages claims, because otherwise nobody will make any decisions. So you have to show that the administrative official acted with malice before the court will award damages in your favor. So that's why people would sometimes push through with their reviews, even if by the time they're done with it, the tender has already been executed. And just because of what we were talking about now, administrative decisions remain valid until they are set aside. If you take long to bring a review, then the court can actually dismiss your application because of that delay. Because there is a need, the public needs to have certainty. There needs to be finality in administrative decisions, because things flow from administrative decisions, and people, very legal and valid consequences flow from administrative decisions, especially where other parties are involved. They might have acted upon that decision that was taken by the administrative official, and then if the court sets aside that decision 1 year, 2 years down the line, innocent third parties might be impacted and prejudiced as a result. So that's why it's important for reviews to be brought as soon as possible. Otherwise, the application could be dismissed on the grounds of unreasonable delay. This is exactly what happened in the case that Nelly was talking about, the the South African Poultry Association case. The application in the High Court, the application was dismissed because of a delay in coming to court with a review. We don't know what the Supreme Court will say. We'll see whether the Supreme Court actually goes into the merits of the application or not. So where the court dismisses the application on the grounds of delay, although it might have heard the matter on the merits, it does not make a decision on the merits in those circumstances. So it doesn't even look at whether or not there is validity in what the applicant is saying. So a delay, whether there has been an unreasonable delay or not, will depend on the facts of each case. Previous one, okay. So the court will look at the particular facts of the case to determine whether there has been an unreasonable delay. Because in one case, 2 months delay could be unreasonable, whereas in another one, if you delay 6 months, it's still okay because of whatever the consequences that might follow or not follow. Okay. So not every 2 cases are the same. So there's a 2-pronged inquiry when considering whether there has been an unreasonable delay. The first is whether the time that it took the litigant to institute proceedings was unreasonable. So the court will look at what has happened in the meantime from the time that the decision was taken to the time that the application was instituted. Do you remember the Radebe case that we discussed earlier in relation to the question of urgency? Those factors are all factors that will be considered also in a review. That was actually a review matter. Well, those factors will be considered to determine whether the time that was taken to institute the proceedings was unreasonable. Then the court will consider whether it should, in the exercise of its discretion, grant condonation for that unreasonable delay. Whilst the first one is not a discretionary issue, so in the first instance, you are looking at the facts. What has the person done? Did they delay unreasonably, factually? It's not you don't exercise a discretion there. The second question as to whether you should condone that delay, that's a discretionary issue. So if the court says, the court might say, yes, the delay was unreasonable, but because of factors A, B, C, and D, I am willing to condone the delay. Here the court will be considering what would be the prejudice to the applicant versus the prejudice to the respondents, the prejudice to the decision maker maybe, or other third parties who may be involved. So for instance, in a tender situation, yes, the person might have taken long, but has the tender been implemented yet? No, it hasn't been. It's been put on hold. Has the parties entered into an agreement? No, they haven't. And then the court might say, okay, in this case, I'm willing to condone it because there will not be any prejudice to any party. But if the tender, the person has started building is halfway already, if I now stop this process, what will be the prejudice to the respondents? So now the employer, the decision maker now has to first go through and looking at the whole process from the start again. Costs might increase, and the building might, when the building, how things just wear out and what do you call them, wear and tear and whatever. If you leave a building site, just leaving it like that, it can also cause you more damages and stuff like that. So those are the factors the court will consider in whether or not to condone the delay. And that is a discretionary issue. People often come to the High Court because it's more efficient than the lower courts, because the lower courts are not necessarily staffed or manned with as many magistrates or clerks or whatever who can deal with those many cases and so on. So they'll come to the High Court, and then get their default judgments there instead of going to the lower courts. But it should actually it's something that falls within the jurisdiction of the magistrate's court. The rules, I believe, or the practice directives say, in those circumstances, you will not be given your costs on a high court scale. You'll get it on the magistrate's court scale. Is that so? Or you won't get costs? You won't get costs. Yes, so the rule, it says you won't get costs. So that's not an alternative remedy. It's the appropriate. So the High Court has jurisdiction over everything. So its jurisdiction is not limited. Let's take it in the context of a review. Yeah. So sometimes the statute under which you sought a decision from an administrative body makes provision for an appeal. And you didn't go through that appeal process, you don't provide any reasons why you haven't gone through that process, then the court can actually dismiss your review application because you have not exhausted all your internal remedies. Yes. So that would go to substantive administrative law, and that's why I wouldn't have dealt with it now. But yes, you're right. If you don't exhaust the internal remedies provided for before you come to court on a review, then it's something that could be taken into account in deciding whether to grant you the relief you seek or to dismiss your application. Yeah. So you might be able to explain why you make use of those internal remedies. There might be some other reason which show that you would not in any event have had a fair hearing or whatever, and then the court might consider still hearing your application. So it's all about what you say. You need to bring it as soon as possible, but it might not be heard as quickly as possible. Yes. That it's the time when you bring it that is considered in considering whether you've delayed or not. So these are the additional prayers that appear normally in a review notice of motion. That's the one that talks about the dispatch of the record and for the person to provide reasons for their decision. So the example of a magistrate, instead of opposing the application, you just give your reasons for your decision. You've seen the application and you must just explain what you did in your reasons, and then you step back and let the court the process take its course. So there we talk about the record that must that makes provision for supplementing the papers. I did this still under the old rules, but it's very similar. So it's just the timelines that differ. Okay. That's the additional sort of piece that comes in a notice of motion for review. It can be applications. The answering affidavit can have many affidavits with it. The replying affidavit can also have many affidavits with it. So before we had a full bench in the High Court. Sometimes they still do a full bench. And then in the High Court, if you are a single bench judge, then you are bound by that full bench decision. But you are not necessarily bound if you are a single bench and there's another single bench making a decision on a similar issue. You're not bound by each other's decisions, but you would normally, what you would do is to say why you don't follow the precedent set by that person. What we call, you distinguish the case. So the review jurisdiction of the Supreme Court is limited. It's only when they decide to exercise that discretion that they will do so, and they do that only in limited circumstances in terms of the Constitution. What can probably happen is, if you have brought it to the attention of the Judge President, that he can perhaps just share the information with his brothers and sisters there in the High Court, so that the next case that comes, the issue can be corrected. Okay, then we are done. That's all for me.